Are machine guns now legal to possess without having to jump through the ridiculous legal hoops currently required by federal law? A few days ago, a federal judge ruled that a man's possession of a machine gun was protected under the Second Amendment, regardless of what federal gun laws may say, and the judge dismissed the machine gun charges against that defendant. So are machine guns now legal despite federal law? Or is it possible that this judge's order is actually just bait in a Second Amendment trap that could lead to more gun control laws being found constitutional? Let's talk about it. I am, of course, attorney Andrew Branca for Law of Self-Defense. Hey folks, I want to take just a moment to invite you all to our upcoming live and 100% free Law of Self-Defense Hard to Convict webinar. This free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me personally, and there's plenty of opportunity for Q&A. Best of all, it's 100% free, but we do limit seats to allow for adequate Q&A. So I urge you to grab your seat right now by signing up at lawofselfdefense.com/hard-to-convict. In fact, go ahead and pause this video and grab your seat right now. I look forward to seeing you all there. So, Justin Bryce Brown, a Mississippi man, was found to have in his home a machine gun and charged with the unlawful possession of that machine gun in violation of federal law. That's a federal felony, good for 10 years in prison. It was uncontested that Brown did in fact have possession of a machine gun, and under circumstances where he'd failed to jump through the legal hoops that federal law imposes in order for that possession to be lawful. So it should be a pretty open and shut possession case. The prosecution naturally taking place in federal court, specifically a U.S. District Court in the Fifth Circuit, which covers Louisiana, Texas, and, of course, Mississippi. Brown's lawyer argued to trial judge Carlton Reeves that the entire case should be dismissed on the grounds that the federal statute in question, the machine gun possession ban, was a patent violation of the Second Amendment and therefore legally null and void. Judge Reeves then somewhat curiously notes about the defense lawyer, he is, in other words, bringing an as-applied challenge to his prosecution. Why do I find this curious? It's the use of the words, in other words. Judge Reeves isn't actually saying that the defendant formally made an as-applied challenge. Judge Reeves writes as if he's making that presumption himself, that he's putting those words into the defendant's mouth. Why does this matter? It matters because if Brown, the defendant, is challenging the constitutionality of the machine gun law generally, then if the judge rules for Brown, he's also ruling that the machine gun law is void generally, and therefore we can all go out and buy machine guns. But if the judge characterizes this as an as-applied challenge, even if Brown didn't narrow his challenge that way himself, then the judge can rule in favor of dismissing this charge against Brown, specifically without having to rule that the machine gun law is void generally. Characterizing this as a mere as-applied challenge, therefore offers this judge a juicy opportunity to use this order as bait in a Second Amendment trap without running the risk of allowing wholesale purchasing of machine guns, which is what I expect is actually what this judge is doing. More on that later. In evaluating Brown's argument for dismissal, Judge Reeves notes that the relatively new test for evaluating the constitutionality of gun control laws that was set out in the 2022 Supreme Court decision of Bruen. Quoting Bruen, "To satisfy this burden to prove a gun control law is not an infringement of the Second Amendment, the government must identify a well-established and representative historical analog of that law. Evidence must be relevantly similar to the challenged law. In assessing similarity, we consider whether modern and historical regulations impose a comparable burden on the right of armed self-defense and whether that burden is comparably justified." Judge Reeves then notes, this is a heavy burden, as it should be. The prosecution in this case argues that the machine gun ban statute should be found by Judge Reeves to be valid even under the Bruen test, arguing that there is a demonstrable history and tradition in American law of prohibiting firearms that are both dangerous and unusual. The problem for the government in this argument, Judge Reeves notes, is that although machine guns are certainly dangerous, the government fails to explain why machine guns should also be found to be unusual. With respect to the element of dangerousness, Judge Reeves notes that really all firearms are dangerous in the sense that they are readily capable of causing serious bodily harm. Revolvers are dangerous. Semi-automatic firearms, both handguns and long guns, are even more dangerous. In fact, with respect to the dangerousness of semi-automatic firearms, Judge Reeves rather gratuitously presents a list of more than 30 cities where what he refers to as horrific mass shootings have occurred with semi-automatic firearms just since the turn of the century. This list he presents caught my eye because it's a list that's not necessary to the legal analysis or the conclusion of this order, and it was maybe the second thing that made me suspect that perhaps Judge Reeves was actually hostile to America's Second Amendment law and was using this order as bait in a trap to elicit a pro-gun control counter-reaction in response. Judge Reeves then notes that as dangerous as revolvers are, and as more dangerous as semi-automatics are, machine guns are obviously even more dangerous yet. But dangerousness is not enough to make the banning of machine guns not an infringement of the Second Amendment. It's also necessary to find that the machine guns are unusual. Judge Reeves notes that Brown, the defendant, claims that there are about 750,000 machine guns lawfully possessed in the United States, and that the prosecutors in this case do not dispute that number. Noting that 750,000 is no small figure, Judge Reeves says that the government has made no argument why such a large figure should not be deemed common rather than unusual, and writes that 750,000 of any kind of firearm is plainly widespread. Finally, we get to Judge Reeves' conclusion in this order, and it's the nature of this conclusion that further makes me believe that this order is not really intended to be pro-Second Amendment and pro-machine gun, but rather is intended to be bait in a Second Amendment trap. That is, I suspect that Judge Reeves may have arrived at his conclusion in this order that Brown's possession of the machine gun is lawful because the federal machine gun ban is an unconstitutional infringement of the Second Amendment as applied to Brown specifically, arrived at that conclusion in order to elicit a response from higher courts finding the exact opposite. Let me explain why I suspect that. First, Judge Reeves is rather explicit that he does not like the history and tradition test of Bruin, not one bit. Reeves writes explicitly that he doubts that the historical approach wielded in these recent Second Amendment cases is the right one, meaning, of course, the approach in which Bruin specifically requires judges to follow history and tradition, evaluate whether new laws are relevantly similar to past laws, and determine whether certain firearms are dangerous and unusual. Reeves then writes, "These tests are deeply concerning to many." By that, of course, we should understand what he really means is that these tests are deeply concerning to me. It's important to keep in mind what the test of gun control constitutionality was prior to Bruin. It was essentially means-end testing, a balancing of public policy interest. If the public policy arguments for gun control were deemed to outweigh the public policy arguments against gun control, then the gun control was found to be constitutional. The trouble with this balancing test is that in the hands of anti-Second Amendment judges, it simply meant that every gun control law was deemed to pass this test and be found to be constitutional. It wasn't until the modern era of Supreme Court Second Amendment decisions, Heller, McDonald, Caetano, and of course Bruin, that it was made clear that the enumerated constitutional Second Amendment right was not subject to a mere balancing test. The test of history and tradition, relevantly similar and dangerous and unusual, were to be the tests used for evaluating the constitutionality of a gun control law moving forward. But in a lengthy footnote, Judge Reeves in this order discounts each of these three tests as subjective, standardless, and really just unworkable. He writes, quote, "Take the relevant similar test, for example. As the DC Circuit Court just explains, there simply is no relevantly similar historical analog to a modern semi-automatic handgun equipped with an extra-large capacity magazine. Judges can instead cherry-pick the historical analogs they wish, discarding contrary examples as ambiguous or inconclusive. As Antonin Scalia wrote, the trick is to look over the heads of the crowd and pick out your friends. Dangerous and unusual, meanwhile, merely combines two standardless words into one term. Everything is dangerous in the right or wrong circumstances. Even water turns dangerous in a flash flood, at a TSA checkpoint, or on the floor of a grocery store. And who is to say that a firearm is unusual? Close quote. Judge Reeves concludes this footnote with this, quote, "The test ultimately turns on a judge's subjective view of data without deference to the other, more democratic branches of government." Close quote. Well, that's an interesting sentence, Judge Reeves. In other words, he's saying the Supreme Court's test set down in case law as a product of the judicial branch of government under Article 3 of the Constitution fails to allow sufficient deference to the legislative branch of government under Article 1 and the executive branch of government under Article 2. And what do the legislative and the executive branches bring to the table in Second Amendment law? Public policy arguments. Judge Reeves is in effect urging for a return to the balancing test for use of judging the constitutionality of gun control laws as that test was used before Heller, McDonald, and Bruen. You know, the balancing test that invariably found all gun control to be constitutional. Judge Reeves goes on to bemoan his view that the modern Supreme Court cases of Heller, McDonald, and Bruen are based on a lack of trust by the Supreme Court of the other branches of government, writing, quote, "At their core, the Supreme Court's recent Second Amendment cases are predicated upon a lack of trust. The Heller, McDonald, and Bruen decisions did not trust that local and state lawmakers had protected their citizens' Second Amendment rights or would protect them going forward. The decisions also expressed doubt that the federal courts were doing enough to protect those rights." Close quote. Well, I think Judge Reeves is exactly correct on this point. The Supreme Court did not trust them. And I also think that the Supreme Court had a lack of trust in state lawmakers and even in the federal courts on Second Amendment issues for damn good reason, because none of them ever saw a gun control law, an infringement of the Second Amendment that they didn't like. The Second Amendment was being treated, as Justice Clarence Thomas noted, as a second-class constitutional right, and the Supreme Court was tired of it. I would also note that the Second Amendment itself, indeed every one of the Bill of Rights, is predicated on a lack of trust. The entire Bill of Rights is an exercise in taking various rights beyond the reach of public policy arguments. The right to free speech, the right to peaceably assemble, the right to legal counsel, the right to a jury trial, the right to be free of unreasonable search and seizure, and of course the right to keep and bear arms. All of these were areas of deep concern for the Founding Fathers, concern that a future government would claim the authority to infringe these rights as a simple matter of public policy. So the Bill of Rights remove all of these and more as areas of law subject to simple public policy preferences. Indeed, if anything, the Second Amendment reflects the greatest possible degree of a lack of trust for the government, because the core purpose of the Second Amendment is to enable the citizenry as a militia to violently overthrow a future tyrannical government. But this Judge Reeves doesn't like this lack of trust and the modern Second Amendment test that relies on history and tradition, noting in passing that, by the way, the actual historians, the experts, all of whom are academics who would advocate for banning civilian-owned guns entirely, those actual historian experts, they all believe that the lawyers and judges finding that gun control laws can be an infringement of the Second Amendment have not gotten it right. He also expresses his own discomfort with having to apply the actual applicable law to the Second Amendment cases, and even longs, hopingly, that his own uncomfortable application of that law to this particular case will later be found to be erroneous and presumably reversed. He writes, quote, "As one of those tasked with applying these new tests, This court understands everyone's confusion. It feels the frustration. But its doubts and the discourse, no matter how serious or justified, cannot deter it from faithfully applying the law, even if that application is later found to be erroneous. Wink, wink. Indeed, in his final paragraph, in which he shares his conclusion on Brown's motion to dismiss the machine gun charges against him, Judge Reeves refers to the mandated Bruin standard of history and tradition analysis as merely, quote, the controlling legal standard of the moment, unquote, as if longing for the moment to pass and for the old balancing test standard to return. The controlling standard of the moment requires this court to determine the contours of acceptable prosecutions through the resolution of continual as-applied challenges based on the evidence and arguments before it. Under that standard, Mr. Brown's as-applied challenge is sustained. His motion is granted, and the case is dismissed. So ordered this 29th day of January 2025, so just a few days ago, United States District Judge Carlton W. Reeves. So Brown is off the hook on his machine gun charge, and presumably is allowed to keep his machine gun. But this order affects only Brown, so it's not a general dismissal of the federal machine gun laws entirely. Worst of all, though, as I said, I suspect this order was really intended as bait in a trap for the Second Amendment. I suspect that Judge Reeves believes that surely all right-thinking people would understand that allowing civilians to possess machine guns is obviously insane, especially given his list of 30-plus cities in which mere semi-automatic firearms were used to commit horrific mass shootings. By extension, then, any method of legal analysis, even if that method is mandated by the Supreme Court itself, that obliges as reasonable and rational a judge as Carlton Reeves himself to have to determine that Defendant Brown is legally entitled to possess a machine gun must itself be a legal analysis that is obviously insane and needs to be discarded. And please, Judge Reeves seems to be pleading to higher courts, please, I beg of you, find my legal analysis to be erroneous and rule that the moment of the Bruin Second Amendment legal analysis of history and tradition, that moment has passed. And note that Reeves can set this bait in this trap without having to run the risk of ordering that the machine gun possession ban is generally unconstitutional, and therefore we can all go out and buy machine guns without worrying about the federal rules by simply issuing this order as an as-applied challenge so its effect is limited only to Brown. So yes, Brown gets to keep his machine gun. No, the order doesn't relieve the rest of us of the burden of the federal machine gun prohibitions. And yes, this looks to me as if, in the words of the meme, it's a trap for the Second Amendment. And that's about all I have to say for the moment about this, except that a link to the full order is embedded in the description of today's show for those who'd like to read the entire thing themselves. As always, I'll close out by reminding all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for thelawofselfdefense.com. Stay safe.